But I think this is an important first step we have to
Senator Anderson.
I have a quick question from the opposition, the fellow that came up, that had the concern. In the use of your UAV, what is the maximum height that you can still track your streams?
Yeah, so that's a great question. It depends on the sensor that we're using. So there's certainly a thermal camera, it helps to fly lower because you get a better resolution. If you fly really high, then you kind of lose, it depends if you're trying to pick up little rocks or sticks or actually salmon spawning up the streams, which is one of the uses. Flying lower actually is better because you pick up a better resolution. So oftentimes I fly at 30 meters, for example. And a lot of that also, I tend to use small drones that are really affordable for my graduate students. And so we try not to fly too high because we also want to keep out of the wind. Because these small drones, they're really affordable and they're small and they're easy to pack up in our research vehicles. So we do tend to fly under 100 feet quite often. Not in the redwoods. The tallest redwood is 379 feet. That's a Federation giant. So, you know, flying between 350 and 370, 400, for me it's it's arbitrary, but lower is actually a lot more helpful if we're trying to map endangered species or we're flying vernal pools, which are highly endangered. We fly really low because we want to get the actual flowers and count the number of flowers that are in there. This, you know, I think the major issue for us is, you know, if we are flying on private land surveying for a private landowner, you know, if we do fly fairly low and we oftentimes when you're mapping, you want to fly a lawnmower pattern over the edge of the property because you got to get enough pictures to stitch together to make a good map. And so you got to blur the edges. That's just how the mapping works. And so if there could be some language about rural ecological farm, you know, sites. I'm not talking, I live in Berkeley, like, and there's a lot of concern about privacy. I don't want to fly over the Berkeley Hills. What I don't want to do is if I'm flying, you know, in Tulare County, if I stray onto someone else's land to image, that I'm going to get charged with trespassing.
I have just a couple follow-up questions for you. So when you fly on somebody's private land to follow that river, do you get permission from the landowner because you're flying awfully low? Yeah,
so I bring up the rivers because it's kind of the river is actually public space. It's actually, you know, you can fly a waterway. It's actually the borders that's often private land. And so if I'm flying a river and someone is on their private property and happens to be skinny dipping or whatever they want to do on their private land, but they're in the river, it creates a gray area. And so you are flying the land, but the imaging is going to pick up private property along the borders of that river as we measure drought stress or as our streams are drying up.
And when I mean, I know this sounds obvious, but when operating that vehicle, it's not automatic. You're actually flying it, so you must have a screen to see where you're going, right?
Yeah, so I actually so I take a tablet and I trace the course of the river on a Google map, and then I program the drone to actually fly that course and come back and land. It's actually pretty risky to take off and land and so I try to not get my students or myself to fly remote controlly. I just do it by circling where I want it to fly, programming the drone and let it take off, and I program the altitude. So I can program in 30 meters or 100 meters or whatnot. And it flies automatic, which is the safest way to fly as opposed to trying to control it yourself. You get confused, the wind picks up, et cetera. This way, if you fly automatically, it adjusts automatically. And so I try not to fly out of the barriers of my survey on that particular property, but it's often difficult to figure out where the property lines are as well. That's not always clear.
Thank you very much. You've been quite helpful. You know, when we were thinking of the delivery to the door, I got to think at some point when they do the delivery, they're going to want to take a picture to show proof of delivery. Or I noticed that when I use one of the services, I have a tracking code and it tells me which airport, where that truck is on its way to my house, I can only imagine they're going to want to give us that same level of service if they decide to use UAVs to deliver packages from Amazon. I'm on track with what you're doing, but I'm just wondering if we're using a sledgehammer on a fly, because I'm concerned, what if I take that drone and I fly up 100 feet up? Your fence doesn't come up 100 feet. It'd be the same as if I took my phone and attached it to a stick and I lifted it over the fence. Am I not violating your privacy the same way, but within I mean, I'm trying to get a gauge on how far we go before we're over the top, that we're so concerned about this. But yet, if I attach this to a stick, or any camera to a stick, and lift it up, now I get if you're on a big sprawling property and I can't go deep into your property, but in the neighborhood I live, my next door neighbor's second story looks into my yard. What do I do about that? I mean, how do I stop that second story from eavesdropping and he may open his windows and listen to what I'm saying as well. I mean, I'm just trying to figure out where this goes, because I agree it's very annoying that somebody's there, but I'm also trying to waive the fact that satellite can take a picture of, that's incredibly accurate, and he gets down to where I can read a bumper sticker on somebody's car. So what I'm worried about is, are we really addressing the issue, or are we just feeling good? And I did look up, and well, it was a quick Google check. They were saying if I were to have a helicopter and I wanted to operate that helicopter, 400 feet was the ceiling that the FAA kicks in at. So you're giving them from 350 to 400 to operate in where that's space that's not regulated by the FAA. Now, you'd probably be more accurate because I just did a quick Google quick search. So I'm just wondering, are we really getting a high return on this bill? Are we really getting what we think we're getting, or are we just complicating issues by not truly addressing it? And I'm not sure what the best answer is.
Yeah,
I'd love for you to
I don't think we're
that.
complicating it. What we're doing is we are making a statement about individuals flying drones in other people's property. That's what we're doing. We're making a statement that says the same way you could not physically put yourself in, that I cannot physically put myself in your backyard and stand there without your permission. That's a trespass. Taking a drone and flying a drone in the same position, if you will, should also be trespass. That's what the bill says.
But if my drone or my camera is on a stick, I haven't violated your space, but I violated your privacy all the same.
That may be. You haven't, but you, and there are offenses for that. I think that's a peeping Tom offense. But if that stick comes over into my yard and watches my kids playing in the backyard, that's a violation. That is a violation of my space. Now, not too many people are going to take cameras and put them on sticks, but they are going to take drones that they buy on Amazon.com, and apparently this is not an uncommon thing. I had a friend who told me a week ago that the same thing happened to her next door neighbor. This is an immediate and direct violation of your space, of your private space, which is your home, which is your backyard. That's what this bill is designed to do. We can go beyond this. As I mentioned, when we introduced this very simple bill, we started getting calls from a police chief of mine called and said, would you expand that to include our police station? Because there are drones that are flying over the back of our station where we bring in witnesses and informants and defendants. We don't want their buddies hanging out there surveilling what's going on in the police station. We've heard that with prisons because they're dropping contraband in prisons. I mean, this is a whole Pandora's box. What I've done is just taken what I believe is a very fundamental right of privacy that is being violated by these drones because there are no rules. We're just creating a rule that conforms with what I think are people's expectations of privacy when you're in your backyard. Now, if you live in a two-story house and your neighbor's right across the way, you have the right to put shades down. They don't have a right to flip those shades up, though, if you want to have your privacy. Essentially, what a drone does is it flips up that shade. It takes away that right of privacy.
Well, I differ with you in the sense that the person from the second story is looking right into your yard and sees your yard. You can't put a shade up on that. But certainly that drone that's at 15, on the 15th floor looking in, a shade would perhaps work for that. The last issue I have is the enforcement. So how do we know whose drone it is? I mean, so let's say the drone's now violated your airspace. I'm not going to be able to run fast enough to chase it home. So I'm just trying to figure out, where do we...
You might if it's your next door neighbor.
Okay.
If you can't find, if you can't, you know, enforcement, if you don't know whose drone it is, that's one thing. But they can be followed. They don't fly necessarily that fast. And, you know, if you find out whose drone it is, rather than go shoot the thing down, you get to bring an action for civil trespass. It's not a criminal trespass.
Well, certainly if you shoot it down, you find out who the owner is pretty fast.
Yes, you do, and you end up paying for the privilege of having shot down his drone on your property. At least that's the way the law seems to be. So,
Senator
again,
Wachowski?
Yeah, since we have a professor here, I get a free question. We've been dancing around this constructive invasion of privacy and talking about the camera and the eavesdropping equipment that goes in, but that's always conditioned about a reasonable person's intrusive behavior. And it seems to me that I don't want to be ageist here, but as we go through each decade, people have a different expectation of privacy. The author has an expectation of privacy. Someone in their 20s and 30s, it's because of the just data and all those things. Would it be helpful if we tried to look at, and again, I don't want to talk about the reasonable persons or the invasiveness, because it seems that you have an opportunity when you're looking at 350 feet to give some clarification of what reasonableness is, and that may be in 2015, because I'm concerned that in 2025, the court cases may be that that's not reasonable for you to think that this camera is taking images of you as they flies over, because everybody has cameras taking pictures of you. Your comment.
Senator, my answer is actually responsive to yours and to Senator Anderson's line of questions. I think we have to just pause for a second and recognize that the bill is, obviously I'm in support of the bill. It achieves narrow goals. And so Senator Anderson's example of someone with the camera on a stick in their yard looking over, seeing down, we're not solving that problem. But we are solving the drone hovering at 45 feet above your barbecue every day when every day when your daughter is swimming in her pool. Right now, we don't have anything in California law to go back to your constituents and say that person shouldn't be parking their drone above property, right? And so we're solving that narrow thing. With regard to the expectation of privacy, directly to your question, by amending 1708.8, basically the paparazzi statute, what we've added in here is a line that says the observation from the drone would be the same type of cognizable harm as if the paparazzi walked upon the land themselves. And so we would still need to satisfy that fifth element, which instead of being reasonable expectation of privacy in the statute says is offensive to a reasonable person. With regard to the inadvertentness, now we're going to get from the civil violation here. We don't have to worry about a criminal penalty. The gentleman from Berkeley brought up the question about the possibility of being charged with a crime. Statutes, as we know in the penal code, are specifically defined, and so we won't be reading in from other provisions what the criminal trespass provision means, which just leaves this modification and how it might affect the common law tort, the common law trespass that we have in California. And again, with some de minimis harms, there's actually a little open question here, but if you interpret the drone as a projectile flying through the space, then that's automatically a trespass that's an actionable harm. However, if you treat it as a trespass upon the land, and this will be what the courts decide to do, then there would have to be some actual damage or nuisance that flows from that trespass. And we have the possibility of a nuisance suit or a trespass suit, but so long as you could prove that there was some substantial interference with the land below. I recognize I just took like a turn down into the weeds, but we're doing a narrow thing here, and the only open question as to what would happen is how it will impact the common law definition of trespass.
Right, but to get to my concern, it would be like per se, if you're in the 350-foot level and you're recording stuff and you're taking camera images, then you're meeting the definition. That's not reasonable, because we've set a level of 350 feet where before we just had.
I think when we went to court, I think that the element of offensive to a reasonable person would be proven. The open question would be, was the individual engaged in a private, personal, or familial activity?
Right.
So the mere delivery of the package on the front step wouldn't satisfy that. But so the reason I think the narrowness is important, because it reaches the category of cases that we would be very concerned about, while of course not being so inclusive that it doesn't touch some of the peripheral cases. That's why I think narrowness is a good thing here.
Any more questions from the committee? Senator, would you like to close it up?
Very briefly, this is new territory, and I think that the bill creates an expectation for the public and people who use drones as to what is acceptable and what isn't, acknowledging the right of privacy that is to Californians a fundamental right written into our Constitution. I think it balances it. I think there will be additional legislation going forward on all these different aspects of drone use and of new technologies for the 21st century. This is very narrowly crafted to address a very simple problem that is defined. We've defined airspace in a way that we believe is justifiable for the state of California to have control over. And on that basis, I would ask for your aye vote.
We have a motion to move the bill? Yeah. All right. Please call the roll.
The motion is due pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Vidak? Anderson? Anderson, no. Hertzberg? Hertzberg, aye. Leno? Monning? Monning, aye. Wachowski? Wachowski, aye.
Four to one on call.
One more. So I was supposed to start off by saying good afternoon. I guess I can say good evening. Mr. Chair and members of the committee, I bring forward to you today SB 414, which is part of the continued effort toward restoring and protecting the rights of same-sex couples in California. This proposal will modernize statutory language to reflect marriage equality in California by replacing the gendered term husband and wife to the gender-neutral spouse throughout 18 code sections. This is an important and necessary measure for several reasons. It's important for statutory language to reflect California law in order to accurately protect and represent the rights of the people. Marriage equality was restored in California when the courts ruled Proposition 8 to be unconstitutional in violation of the Equal Protection Clause. Codifying case law is necessary because self-represented litigants rely on statute, and currently language in statute does not reflect case law, which then creates confusion about what rights are available to them. And our probate code, for example, has many significant applications for married couples and the individual rights of a spouse. Again, self-represented litigants rely on these provisions to understand their rights and duties under the law. Similar measures have been taken to ensure the rights of same-sex couples, to make sure those rights are protected. And Senator Leno, I was going to give him a plug, but he's not here, I'll give him a plug anyway, okay? Senator Leno's staff, if you're listening, his measure 1306, conform marriage statutes to establish legal precedent and court decisions. California's family code now reflects marriage equality in the state. We're trying to do that with other codes. Efforts toward using gender-neutral language in statutory law are in line with a widespread trend throughout the country. And according to the National Conference of State Legislatures, half of the states in the United States have made efforts to revise their statutes and their constitutions to remove language that represents a gender bias and replace it with gender-neutral language. I have with me today to talk about the bill Joe Michael Esquire from Equality, California, and would ask for your aye vote.
Go
Good
ahead.
afternoon, Mr. Chair and members. I'm not sure I've ever been introduced that way. Thank you, Senator Jackson. Joe Michael for Equality California. We are proud to support this bill. We actually sponsored, along with NCLR, Senator Leno's bill last year on this similar issue. And we thank Senator Jackson for bringing this measure forward to take the next steps to implement the series of decisions culminating in the U.S. Supreme Court decision in Hollingsworth versus Perry in June 2013, restoring the freedom to marry to California. Not only is it important in and of itself for state statutes to reflect that marriage equality is the law of the land in California and to use gender-neutral language whenever possible in general, these changes to California code are particularly important to litigants who represent themselves, as Senator Jackson stated. And one of the benefits of staying past 5 p.m. is getting to do everyone else's Me Too's. So I also get to state support on behalf of the National Center for Lesbian Rights, the American Civil Liberties Union, and the National Association of Social Workers California chapter, per the request of my esteemed colleagues at those organizations. We all respectfully urge your aye vote, and thank you very much.
And I might say that this, I did accept as authors' amendments those that are listed on page 5. So that would be the motion.
Witnesses in opposition? All right. Questions from the committee?
As amended. It had to be moved as amended.
Moved as amended. All right, Senator, would you like to close?
Ask for your aye vote.
Call for roll.
The motion is due pass as amended to the Senate floor. Jackson? Aye. Jackson, aye. Vidak?
Aye.
Vidak, aye. Anderson?
Aye.
Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski? Wachowski, aye.
On call, 6-0.
Thank you, Senator Vidak, for a yeoman's job. We're going to lift the calls on those items that that are still left open, and if we could call Senator Leno and, oh, all right, he's already been called. The efficiency here is most impressive. So if you would go to the consent calendar at this point. The consent calendar, let's call the absent members on the consent calendar. The vote is now.
Anderson? Consent.
The consent.
Anderson, aye.
All right, 7-0, the consent calendar is out. File item number 1, Senator Lara, the vote count is 6-0. Please call the absent members.
Wachowski? Not voting. Okay. Wachowski not voting. Okay. So it's 6-0.
All right, that bill has out 6-0. Next item, file item 2, Senator Liu, SB 68. Please call the absent members.
Leno? Leno, aye.
That bill has 7-0. That bill is out. File item 3, SB 128. The bill is 4-2. Please call the absent members.
Wachowski? Aye. Wachowski, aye.
5-2. That bill is out. File item 4. The vote count is 4-1. Please call the absent members.
Vidak? Leno. Leno, aye.
All right, 5-1, that bill is out. File item 6, SB 414 by Jackson. The vote is 6-0.
Leno? Aye. Leno, aye. 7-0.
7-0, that bill is out. And what is it? Well, because Senator Leno led the way. Is that it?
Yep, that's it.
All right. That concludes the hearing for today. Thank you, members, for your attention. We are adjourned.